हेलो फ्रेंड्स, FIR शब्द के बारे में आपने सुना ही होगा। FIR सुनकर आम आदमी को पुलिस से डर लगना शुरू हो जाता है। उसकी वजह सिर्फ इतनी है कि सभी को पुलिस FIR की जानकारी नहीं होती। इसलिए हम इस वीडियो में आज चर्चा करने वाले हैं FIR के बारे में जरूरी पॉइंट्स, और हम उम्मीद करते हैं आपको इसका भरपूर लाभ होगा। पुलिस FIR क्या है? प्रथम सूचना रिपोर्ट FIR पुलिस द्वारा तैयार किया गया एक लिखित दस्तावेज है जब उन्हें किसी संज्ञेय या गैर संज्ञेय अपराध के बारे में जानकारी मिलती है। ये सूचना की वो रिपोर्ट है जो पुलिस तक सबसे पहले पहुंचती है और इसीलिए इसे प्रथम सूचना रिपोर्ट कहा जाता है। पुलिस FIR का क्या महत्व है? यह आमतौर पर एक संज्ञेय अपराध के पीड़ित द्वारा या उनकी ओर से किसी व्यक्ति द्वारा पुलिस में दर्ज कराई गई शिकायत से उत्पन्न होता है, लेकिन कोई भी ऐसी रिपोर्ट मौखिक या लिखित रूप में पुलिस को दे सकता है। इसलिए संज्ञेय अपराधों के बारे में जानना आवश्यक है। FIR और पुलिस शिकायत में क्या अंतर है? शिकायत एक नागरिक द्वारा पुलिस को दी गई रिपोर्ट है, जबकि प्राथमिकी शिकायत के आधार पर पुलिस द्वारा तैयार किया गया एक औपचारिक दस्तावेज है। प्राथमिकी बनाम शिकायत एक प्राथमिकी आपराधिक न्याय प्रक्रिया में पहला कदम है, जबकि एक शिकायत जरूरी नहीं कि जांच की ओर ले जाए। हमारा भारतीय कानून दो प्रकार के अपराधों पर विचार करता है, एक संज्ञेय अपराध, दूसरा असंज्ञेय अपराध। संज्ञेय अपराध वह है जो बहुत गंभीर अपराध है, जैसे बलात्कार, हत्या, चोरी आदि। गैर संज्ञेय अपराधों के उदाहरणों में जालसाजी, धोखाधड़ी, मानहानि और इसके लिए संज्ञेय अपराध के शिकार व्यक्ति द्वारा या उसकी ओर से किसी के द्वारा पुलिस में शिकायत दर्ज कराई जाती है। कोई भी संज्ञेय अपराध होने की शिकायत मौखिक या लिखित रूप से पुलिस को कर सकता है। यहाँ तक कि एक टेलीफोन संदेश को भी प्राथमिकी माना जा सकता है। असंज्ञेय अपराध है गैर गंभीर अपराध जैसे हमला, धोखाधड़ी, जालसाजी, मानहानि, सार्वजनिक उपद्रव आदि गैर संज्ञेय अपराध है। CRPC की धारा 155 के अनुसार यदि एक पुलिस अधिकारी को एक गैर संज्ञेय अपराध के बारे में सूचना मिलती है तो नागरिक को स्टेशन डायरी में मामला दर्ज करना होता है और सूचना देने वाले को मजिस्ट्रेट के पास भेजना होता है। इसमें पुलिस न तो प्राथमिकी दर्ज कर सकती है और न ही अदालत की अनुमति या निर्देश के बिना जांच या गिरफ्तारी कर सकती है। इसे गैर संज्ञेय अपराध के रूप में जाना जाता है। पुलिस FIR कितने प्रकार की होती है? प्राथमिकी दो प्रकार की होती है। एक प्रारंभिक परीक्षा के लिए प्रथम सूचना रिपोर्ट FIR, शून्य प्राथमिकी, संज्ञेय अपराध और गैर संज्ञेय अपराध। मेंस के लिए दूसरा प्रथम सूचना रिपोर्ट FIR, संज्ञेय अपराध और गैर संज्ञेय अपराध। हमारा भारतीय कानून दो प्रकार के अपराधों पर विचार करता है, एक संज्ञेय अपराध, दूसरा असंज्ञेय अपराध। इसलिए अगर पुलिस प्राथमिकी दर्ज करने से इनकार करती है तो पीड़ित पक्ष के पास आपराधिक या किसी अन्य शिकायत का पीछा करने के कई अधिकार है। लोग शिकायत दर्ज कराने के लिए स्थानीय मजिस्ट्रेट या स्थानीय अदालत से संपर्क कर सकते हैं, या पुलिस अधीक्षक या पुलिस आयुक्त के समक्ष शिकायत की जा सकती है और उसके बाद ऐसे अधिकारी स्वयं जांच कर सकते हैं या अपने अधीनस्थ किसी अधिकारी को जांच के लिए निर्देशित कर सकते हैं। झूठी FIR हुई तो आप क्या करेंगे? जिस पीड़ित के खिलाफ झूठी प्राथमिकी दर्ज की गई है वो संविधान के अनुच्छेद 226 के तहत रिट याचिका दायर कर सकता है और इस तरह की झूठी प्राथमिकी को रद्द करने के लिए उच्च न्यायालय का दरवाजा खटखटा सकता है। यदि उच्च न्यायालय को लगता है कि झूठी प्राथमिकी के पीड़ित के साथ घोर अन्याय हुआ है तो वह उसे रद्द करने के लिए जा सकता है। ये ध्यान रखने के लिए महत्वपूर्ण है, प्राथमिकी दर्ज होने के बाद पुलिस मामले की जांच शुरू करने के लिए कानूनी रूप से बाध्य है। जांच की प्रक्रिया में साक्ष्य एकत्र करना, गवाहों से पूछताछ करना, अपराध स्थल का निरीक्षण करना, फोरेंसिक परीक्षण, बयान दर्ज करना आदि शामिल है, लेकिन ये यहीं तक सीमित नहीं है। सरकारी कर्मचारी पर प्राथमिकी का प्रभाव: यदि मुकदमे के अंत में अदालत उस व्यक्ति को दोषी घोषित करती है जिसके खिलाफ प्राथमिकी दर्ज की गई है तो उसे सरकारी नौकरी से हटाया जा सकता है, वह भी सभी मामलों में नहीं। उस व्यक्ति को नौकरी से हटाया जा सकता है यदि उसे ऐसे मामले में दोषी ठहराया जाता है जहां आरोप गंभीर प्रकृति के हैं या अपराध में नैतिक अधमता शामिल है। FIR आपके करियर को बाधित करने के लिए नहीं है, क्योंकि पुलिस हिरासत में आपकी हिरासत 48 घंटे से कम थी। हालांकि अदालती मामले में UPSC या किसी भी सिविल सेवा की अंतिम परीक्षा पास करने से पहले खुद को बरी करने की कोशिश करें। मामले में सजा आपको सरकारी नौकरी पाने में मदद नहीं कर सकती है। क्या व्यक्ति उस पर FIR के बाद अपना पासपोर्ट आवेदन कर सकता है? हाँ, भले ही किसी व्यक्ति के खिलाफ कोई आपराधिक मामला हो, चाहे वो 498 हो या कोई अन्य मामला लंबित हो, वो पासपोर्ट प्राप्त कर सकता है। FIR दर्ज कराने की प्रक्रिया क्या है? आपराधिक प्रक्रिया संहिता 1973 की धारा 154 के तहत FIR दर्ज करने की प्रक्रिया दी गई है। FIR में सही उल्लेख करने के लिए निम्नलिखित विवरण इस प्रकार है। शिकायतकर्ता का नाम और पता, उस जगह की तारीख, समय और स्थान जहां घटना हुई थी। घटना के तथ्य, शामिल व्यक्तियों का नाम और विवरण, शिकायतकर्ता की व्यक्तिगत जानकारी और घटना के आवश्यक विवरण दिए जाने के बाद कुछ महत्वपूर्ण कदम हैं जिन्हें ध्यान में रखना आवश्यक है। सूचना दिए जाने के बाद इसे लिखना पुलिस अधिकारी का कर्तव्य है। दूसरी बात, शिकायत लिखने के बाद वह आपको वही सुनाए। तीसरा, शिकायत में आपके द्वारा दिए गए विवरण की पुष्टि करने के बाद उस पर विधिवत हस्ताक्षर किया जाना चाहिए, या जो लोग पढ़ और लिख नहीं सकते हैं वे उस पर अपना अंगूठा लगा सकते हैं। चौथा, ये शिकायतकर्ता का अधिकार है कि वो FIR की प्रति निःशुल्क प्राप्त करे। प्राथमिकी दर्ज करने में देरी के कारण होने वाले परिणाम। FIR दाखिल करने में हुई उचित देरी के लिए हम जो उपाय कर सकते हैं उससे परे एक ही सिक्के के दो पहलुओं की तरह इसके परिणाम भी है। घंटों में देरी के अनुसार हर बढ़ते घंटे में अलग अलग परिणाम होते हैं। 5 घंटे की देरी संदेह की दृष्टि से नहीं देखा गया। 12 घंटे की देरी, FIR दर्ज करने में 12 घंटे की देरी साक्ष्य कानून के दायरे में आती है। 15 घंटे की देरी, जब 15 घंटे की देरी से प्राथमिकी दर्ज की जाती है तो आरोपी के झूठे आरोप से पूरी तरह इनकार नहीं किया जा सकता है। 5 दिनों की देरी, अभियुक्त संदेह के लाभ का हकदार हो जाता है। 14 दिनों की देरी, 14 दिनों की देरी के बाद दर्ज किए गए आरोप के आधार पर किसी व्यक्ति को दोषी ठहराने के लिए मजबूत और वैध कारण की आवश्यकता होगी। What is police FIR? First Information Report. FIR is a written document prepared by the police when they receive information about the commission of a cognizable or non-cognizable offense. It is a report of information that reaches the police first in point of time, and that is why it is called the First Information Report. What is importance of a police FIR? It generally stems from a complaint lodged with the police by the victim of a cognizable offense or by someone on their behalf. But anyone can make such a report either orally or in writing to the police, so it is necessary to know about cognizable offenses. What is difference of a police complaint between FIR? A complaint is a report made by a citizen to the police, while in FIR is a formal document prepared by the police based on the complaint. FIR vs. complaint. An FIR is the first step in the criminal justice process, while a complaint does not necessarily lead to an investigation. Our Indian law considers two types of offences. 1. Cognizable offence. 2. Non-cognizable offence. Cognizable offence is that which is very serious offence like rape, murder, theft, etc. Examples of non-cognizable offences include forgery, cheating, defamation. And for this, a complaint lodged with the police by the victim of a cognizable offence or by someone on his/her behalf. Anyone can report the commission of a cognizable offence either orally or in writing to the police. Even a telephonic message can be treated as an FIR. Non-cognizable offences, non-serious crimes such as assault, cheating, forgery, defamation, public nuisance, etc. are non-cognizable offences. As per Section 155 of the CRPC, if a police officer receives information about a non-cognizable crime, the citizen is supposed to enter the case in the station diary and refer the informant to the magistrate. In this, police can neither register the FIR nor can investigate or effect arrest without the express permission or directions from the court are known as non-cognizable offences. How many types of police FIRs? There is 2 types of FIR, one for prelims, first information report, FIR, 0 FIR, cognizable offence or non-cognizable offence. Second for mains, first information report, FIR, cognizable offence or non-cognizable offence. How many types of police FIRs? There is 2 types of FIR, one for prelims, first information report, FIR, 0 for cognizable offence or non-cognizable offence. Second for mains, first information report, FIR, cognizable offence or non-cognizable offence. Our Indian law considers 2 types of offences, one cognizable offence, second non-cognizable offence. So, if the police refuse to file FIR, the aggrieved party has several rights to pursue criminal or any other complaint. People can approach the local magistrate or the local court to file a complaint. Or a complaint can be made before the superintendent of the police or commissioner of police, and thereafter, such officers may investigate themselves or direct an officer subordinate to them to investigate. If FIR is lodged false, then what you will do? The victim against whom the false FIR has been lodged can file a writ petition under Article 226 of the Constitution and can thus approach the High Court to quash such false FIR. If the High Court finds that grave injustice has been caused to the victim of the false FIR, then it can go for quashing of the same. It is important to note that, once an FIR has been filed, the police are legally bound to start investigating the case. The process of investigation includes, but is not limited to, collecting evidence, questioning witnesses, inspecting the crime scene, forensic testing, recording statements, and so on. Effect of FIR on government employee. If at the end of trial, the court declares the person against whom FIR has been lodged guilty, then he is liable to be removed from a government job. That too is not in all cases. The person can be removed from the job if he is convicted in case where charges are of serious nature or offense involves moral turpitude. FIR is not to hamper your career, as your detention in police custody was less than 48 hours. However, in court case, try to get yourself exonerated before you clear the final exam of UPSC or any civil services. Conviction in the case may not help you get government job. Can person apply his passport after FIR on him? Yes, even when a person has a criminal case, be it 498A or any other pending against him, he can get a passport. What is the procedure of lodging an FIR? The procedure of filing the FIR is given under Section 154 of the Criminal Procedure Code 1973. Following details that need to be mentioned correctly in an FIR are as follows: name and address of the complainant, date, time and location of the place where the incident took place, facts of the incident, name and description of the persons involved. After the personal information of the complainant and the necessary details of the incident are given, there are few important steps that need to be kept in mind. Once the information is given, it is the duty of the police officer to write it down. Secondly, after writing down the complaint, he should recite the same to you. Thirdly, after verifying the details given by you in the complaint, it should be duly signed off. For the people who cannot read and write, they should put their thumb impression on the same. Fourthly, it is the right of the complainant to get a copy of the FIR, free of cost. Consequences that are caused due to delay of filing an FIR, beyond the remedies that we can take for the reasonable delay caused in the filing of FIR, like the two sides of the same coin, it has consequences also. According to the delay in hours, there are different consequences in every increasing hour. 5 hours delay, not seen with suspicion. 12 hours of delay. Delay caused of 12 hours in the filing of FIR comes in the purview of evidence law. 15 hours of delay. When the FIR is lodged with a strong delay of 15 hours, the false implication of accused cannot be completely ruled out. 5 days of delay. Accused becomes entitled to benefit of doubts. 14 days of delay. It would be needing the strong and valid reason for conviction of a person based on an allegation lodged after the delay of 14 days. The appellant, accused, has preferred this criminal appeal US 374-3 of FIR. C. Aggrieved by the judgment of conviction and sentence passed by the XLII Additional Judgment CRL. Appeal No. 252482018 Chief Metropolitan Magistrate Bengaluru in CC No. 55631201 on the 1st of December 2018 for an offence punishable US 500 IPC. 2. The appellant is the accused and respondent is the complainant before the court below. The rank of both the parties are referred before the court below. 3. The brief facts of complaint is as under. Now, to understand police case and court judgment, let us discuss judgment and court case as an example. The appellant, accused, has preferred this criminal appeal US 374-3 of FIR. C. Aggrieved by the judgment of conviction and sentence passed by the XLII Additional Judgment CRL. Appeal No. 252482018 Chief Metropolitan Magistrate Bengaluru in CC No. 55631201 on the 1st of December 2018 for an offence punishable US 500 IPC. 2. The appellant is the accused and respondent is the complainant before the court below. The rank of both the parties are referred before the court below. 3. The brief facts of complaint is as under. The complainant was working with ITC Limited, having its registered office at Kolkata, and he served as a director from 2001 till he retired in the year 2011. During his tenure as a director of the company, the complainant was holding the finance portfolio also. The accused has been writing various mails making defamatory statements against the complainant and others, out of which in the email dated the 8th of October 2012 he made false, malicious and defamatory allegations against the complainant and others which are punishable under various provisions of law and in respect of judgment CRL. Appeal No. 252482018, which the complainant has preferred complaint. The accused was originally employed with the company. The accused opted to retire prematurely and his retirement from the services of the company came into effect on the 30th of April 2010. At the time of his retirement, the accused was occupying a flat belonging to the company at Chennai. The accused requested the company to permit him to continue to occupy the said flat till the 30th of August 2010, citing various reasons, including reasons that he wanted to give adequate notice to his own tenant and that house shifting normally does not take place between the 15th of July to the 15th of August for sentimental reasons. The company consented to the said requests and permitted the accused to continue to use the said flat till the 30th of August 2010. The accused did not vacate the flat even after the 30th of August 2010 and the company was constrained to file a complaint EOCC number 122/2010 before the adult Chief Metropolitan Magistrate, EOI, Egmore US 630 of the Companies Act 1956 seeking possession of the flat illegally occupied by the accused. In the said case, the accused raised various judgment CRL. Appeal No. 252482018's untenable contentions and also sought to harass the directors and officers of the company, including the complainant. This was challenged before the High Court of Judicature at Madras, which by its order dated the 22nd of June 2011 held against the accused. The accused filed special leave petition before the Honorable Supreme Court of India challenging the order dated the 22nd of June 2011 passed by the High Court, and by an order dated the 22nd of July 2011, the Supreme Court dismissed the SLP filed by the accused. Thereafter, by an order dated the 28th of July 2011, the Supreme Court dismissed the SLP filed by the accused. Thereafter, by an order dated the 28th of July 2011, the adult Chief Metropolitan Magistrate, Egmore, Chennai held the accused guilty under Section 630 of the Companies Act 1956 and directed him to vacate the flat within 30 days. 4. The complainant further submits that accused has been writing various letters to the officers and directors of the company making false, factually inaccurate and unsubstantiated allegations. On the 8th of October 2012, the accused judgment CRL. Appeal No. 252482018 wrote an email to various directors of the company and the company secretary of the company. In the said mail, the accused has made various false and unsubstantiated allegations. The accused has claimed that the 2009 accounts have been retrospectively manipulated in 2010. By this statement, the accused seeks to create an impression that the company's accounts for the year 2009 were manipulated in the year 2010. The accused has falsely made this claim with full knowledge of the fact that the company's accounts for the year 2009, financial year 2008-09, were approved by the shareholders of the company in July 2009. In 2010 only, the accounts of the company for the year 2010, financial year 2009-10, would come up for consideration, and there was no question of retrospective manipulation of the accounts of the company for the year 2009. By making this false statement, the accused sought to give an impression and a false alarm to the recipients and readers of the said mail that the company and/or its directors are indulging in the activity manipulating the accounts, and that judgment CRL. Appeal No. 252482018 to retrospectively. The words manipulated and retrospectively have been used by the accused deliberately. While using the word manipulated, the accused sought to give the impression to the recipients and reader of the mail that the company's accounts do not reflect the true and correct picture. While using the word retrospectively, the accused meant that the accounts of the company for the year 2009 were not true or correct to begin with, and that in the year 2010 they were manipulated and given retrospective effect. This is completely incorrect and false. The statement and claim that 2009 accounts have been manipulated retrospectively is per se defamatory. The accused falsely claimed that such retrospective manipulation was made with no explanatory notes or reasons given in the schedules. The accused was a senior manager with the company and he knew the manner of reporting of the company's accounts, and he sought to create an impression in the minds of the receipts and readers of his aforesaid mail that the company's accounts for the year 2009 were manipulated. Judgment CRL. Appeal No. 252482018 retrospectively, with no explanatory notes or reasons given in the schedules. The action of the accused in making these allegations is not in good faith and made with ulterior and malified motives to tarnish the image of the complainant. 5. The complainant further submits that statutory auditor of the company was changed in the financial year 2009 thus. The accused has described such a change as a year of unusual auditor transition. By terming such a change as unusual, the accused sought to create impression that the company had manipulated its 2009 accounts retrospectively, and in order to achieve such manipulation, change of auditors was also done. The claim of the accused is false and untrue. The accused also stated in his mail that it was for the recipients of his said mail to cross-check the facts as a part of supervisory oversight and gauge the lack of transparent disclosure and misleading impression given to the shareholders. The accused has also stated in his mail that Y.C. Deveshwar and the complainant signed the judgment CRL. Appeal No. 252482018 accounts for both the years US 217, though AA. By these statements, the accused deliberately sought to give an impression to the receipts of his aforesaid mail and its readers that the complainant and Deveshwar are guilty of manipulating the accounts of the company and that they lack professional ethics and/or competency. The complainant was the finance director of the company during 2009 and 2010. The complainant had signed the 2009 and 2010 accounts of the company in his capacity as the finance director of the company. Presently, the complainant is a non-executive director of the company. The complainant is recipient of the Best CFO award given by Business Today magazine in the year 2005 and other awards. The accused was reporting to the complainant at the time of his premature retirement from the services of the company. The accused was expecting some financial benefits over and above his entitlement at the time of his premature retirement from the company, and he did not get the same. The accused was also found guilty US 630 of the Companies Act in the judgment CRL. Appeal No. 252482018 case filed by the company. It is obvious that the accused is harboring some grudge against the complainant, and he is engaged in this campaign to malign, defame and harass the complainant and other officers and directors of the company. The accused has made statements and claims to various individuals with the sole intention of defaming the complainant in the minds of the recipients and readers of his aforesaid mail. 6. The complainant further submits that the accused has addressed, published and communicated false, malicious and defamatory statements within his mail dated the 8th of October 2012 to various individuals named in the said mail. He also requested Mr. B.B. Chatterjee, the company secretary of the company, to confirm receipt of his said mail and circulate to all members of the board of directors. The intention of the accused in writing the said mail to various persons is to defame the complainant in the eyes of the recipients and readers of the said mail and portray him as a judgment CRL. Appeal No. 252482018 person of careless character and/or a person of unethical professional conduct, behaviors, and to harm his reputation among the people known to the complainant and other professionals. The accused also addressed, published, circulated and communicated scandalous, defamatory and malicious statements to various individuals who are on the board of directors of the company during the year 2009 and 2010 with the object of making such individuals suspect the professional integrity and competence of the complainant and harm the reputation of the complainant. The statements, claims made by the accused in the aforesaid mail dated the 8th of October 2012, particularly portions concerning complainant, are per se defamatory. The accused has not acted in good faith in making these reckless, malicious and defamatory statements. The accused has chosen to make such false, malicious, mischievous and defamatory statements after a period of 2 years after his retirement without any basis or reason, but with the objective of unjustly enriching himself. The accused know and has judgment CRL. Appeal No. 25,248/2018 reason to know that the allegations made by him in the said mail are not true and they are false. The accused has sent such an email from his email ID RAMABADRA and Srinivasan mridshrini@yahoo.com to the official email addresses as well as personal email addresses of various individuals for the purpose of causing annoyance, inconvenience, insult, intimidation, enmity, hatred and ill will. 7. The complainant further submits that the statements made by the accused in the said email have caused incalculable harm to the complainant's reputation and that the complainant is aggrieved by the wild and reckless allegations made by the accused. The said imputations have lowered the reputation of the complainant in the estimation of his colleagues and friends both inside and outside the organization. The complainant submits that the person who read the said mail contacted the complainant and wanted an explanation from the complaint since ITC Limited is a public judgment CRL. Appeal No. 252482018 Limited Company of International Repute. The accused is liable to be punished for defamation for publishing and circulating such false imputations and thereby causing damage to the complainant. Hence, the accused has committed an offense US 499 punishable US 500 of IPC by sending the said communication with offending contents by email. The accused has also committed the offense publishable US 66A of the Information Technology Act. The complainant is resident of Bangalore and defamatory mail by the accused has been forwarded by the company secretary of the company to the complainant and received by the complainant in Bangalore. Various individuals to whom the said defamatory mail was addressed by the accused also called the complainant at Bangalore to inquire about the contents of the said mail. The complainant resides within the jurisdiction of the Mahadevpura police station. Hence, the complainant constrained to file the complaint. The complainant prays to take the cognizance for the offence judgment CRL. Appeal No. 252482018 punishable US 499 of IPC punishable US 500 of IPC and Section 66A of the Information Technology Act and other offences as the court deems fit and proper against the accused and for prosecute the accused according to law. 8. That on the 30th of October 2012 IACMM, Bangalore, taken cognizance of the offence punishable US 499, 500 of IPC against the accused. Thereafter, on the 30th of January 2013, the IACMM, Bangalore ordered for registration of criminal case against accused for the offence punishable US 500 of IPC and US 66A of it Act. Again, on the 7th of August 2015, IACMM, Bangalore passed orders that the complainant counsel filed memo stating that since Honorable SC has struck down Section 66A of IT Act as unconstitutional and the remaining offence of defamation comes within the territorial jurisdiction of Mahadevpura PS and as such to transfer the above case to ex-ACMM, Bangalore. On the said memo, IACMM Bangalore passed order to send the entire records to ex-ACMM, Bangalore. The magistrate court recorded the accusation against the accused and accused has pleaded not guilty and claimed to be tried. The magistrate court recorded the evidence of complainant PW.1 and one witness BB Chatterjee as PW. 2 and XP1 to XP20 were marked. Judgment CRL. Appeal No. 252482018. Thereafter, the magistrate court recorded statement US 313 CR. PC regarding incriminating evidence came against accused. He denied the same and in the statement US 313 CR. PC the accused not stated about leading of defense, evidence. Thereafter, the lower court on hearing the arguments on both sides after making note of the orders passed by IACMM, Bangalore, relating to Section 66A of IT Act, in the judgment, proceeded to pronounce the judgment on the 1st of December 2018 convicting the accused for offence punishable US 500 of IPC, sentencing him to pay fine of 5,000 rupees per for the offence US 500 of IPC and in default of payment of fine amount accused shall undergo simple imprisonment for 30 days. And out of the said fine amount of 5,000 rupees per Rs. 4,000 shall be paid to the complainant as compensation and remaining 1,000 rupees per shall be paid to the state towards expenses incurred in the prosecution as contemplated US 357 of CR. PC. Aggrieved by the said judgment about conviction accused, appellant has preferred the present appeal on following grounds. 9. The appellant, accused, submits that the impugned judgment and sentence passed by the learned magistrate is opposed to law, facts and probabilities in the case and the same is liable to be set aside. The learned magistrate has judgment CRL. Appeal No. 252482018 erred in not extending the benefit of provisions of Probation of Offenders Act 1958. Admittedly, the appellant is a first-time offender and he was not found to have been convicted earlier. Soon after the judgment, the learned magistrate, without extending the benefit of US 360 CR